Hi and welcome back to the channel. Before I start, this video is going to be quite long, but I ask you to watch it in its entirety because it contains some very important information. I will also say up front that I know that the Starmer regime changed the name of the bill to the Universal Credit Bill. However, when the bill was passed at the second and third reading stages, there were no legally binding agreements to implement the concessions offered, and the removal of the personal independence payment eligibility criteria changes was only postponed until the end of the TIMS review, and there are no legally binding agreements to implement those findings either. As such, I'm basing all of this on the original bill. So let's get started then. I have maintained that the Universal Credit and Personal Independence Payment Bill breaches the law in England and Wales. So I've done a quick bit of research aided by ChatGPT to see if it does breach the law and where the conflicts occur. Let's look at the Equality Act 2010 first. The UC and PIP Bill comes into conflict with that Act of Parliament if the bill treats disabled people less favourably than others without objective justification, or introduces criteria that indirectly discriminate against people with disabilities or protected characteristics. Now, the Starmer regime says that the bill is designed to support people with disabilities or low income. But if the 2025 bill tightens eligibility or assessment rules in a way that disadvantages specific groups without proportionate justification, it may raise legal concerns. Let's add a little more detail to get the point across. The proposed changes, particularly the introduction of the 4-point threshold on a single daily living PIP descriptor, and the cutting or freezing of the UC health element, are likely to result in indirect disability discrimination contrary to sections 19 and 29 of the Equality Act 2010. And the groups that these measures disproportionately disadvantage are individuals with physical disabilities, e.g. arthritis, chronic pain, who may score moderately across multiple descriptors but not 4 points in any one category. People with visual impairment who incur ongoing daily living costs but may not meet the revised threshold, or those with mental health conditions and neurodivergent profiles whose fluctuating symptoms defy rigid assessment models. The bill also conflicts with the Equality Act 2010 because there was no published Equality Impact Assessment, EIA, available at the time of the consultation that the Starmer regime ran. This is a breach of the Public Sector Equality Duty, Section 149E of the Equality Act 2010, which requires public bodies to have due regard to the need to eliminate discrimination and advance equality of opportunity. This renders a decision-making process legally vulnerable to judicial review. Now let's look at the relevant key rights in the Human Rights Act 1998 and the European Convention on Human Rights that are open to be affected by the bill. Article 8 is a respect for private family life. Article 14, prohibition of discrimination. Article 1, Protocol 1, protection of property, which includes certain welfare benefits. Article 3, freedom from inhuman or degrading treatment. Due to its differential treatment of new versus existing universal credit claimants, and claimants meeting narrowly defined conditions versus others with substantial needs, the bill is potentially unlawful discrimination under Article 14 of the European Convention on Human Rights, read in conjunction with Article 1, Protocol 1, right to peaceful enjoyment of possessions, Article 8, the right to family and private life, and possibly Article 3, prohibition of inhuman or degrading treatment in cases where withdrawal leads to destitution or severe mental health crises. The Court of Appeal rulings in TP&AR versus Secretary of State for Work and Pensions 2020 and TD and others versus SSWP 2020 provide clear precedent. Cost saving alone cannot justify discriminatory treatment of disabled people. In those cases, the Department for Work and Pensions was found to have unlawfully discriminated against several disabled claimants by removing benefits without transitional protection. The bill conflicts with the Human Rights Act and the European Convention on Human Rights if it removes essential support to a vulnerable group, e.g. disabled persons, without justification, results in destitution, hardship, or lack of access to basic needs, or if it discriminates without objective justification or proportionate purpose. Sound familiar? Now, let's look at a structured legal assessment of how the Universal Credit and Personal Independence Payment Bill could conflict with the Equality Act 2010 and the Human Rights Act 1998, embedding the European Convention on Human Rights, but with a breakdown by the type of disability a person might have. First, we need to provide an overview of the proposed changes contained in the bill and how the STAMA regime was warned about the possible effects. 1. PIP, the new eligibility rule. Claimants must score 4 or more points in at least one daily living descriptor, in addition to the existing aggregate threshold. Estimated approximately 800,000 claimants could be affected, losing an average of £4,500 a year. 2. Universal credit health-related top-up, frozen for existing claimants, cut for new claimants from April 2026, halved in amount essentially, unless they meet the severe conditions criteria. Approximately 2 million existing and 750,000 new claimants will be impacted. When the proposals were announced, disabled rights groups warned that the bill will push hundreds of thousands into deeper poverty and undermine existing protections. The STAMA regime ignored the warning. The Equality Act prohibits both direct and indirect discrimination on the basis of disability. So how does the bill affect different groups based on their particular disability? People with physical disabilities, arthritis, back pain, mobility impairments, often score across several daily living descriptors, but rarely score 4 in any one. The 4-point rule disproportionately excludes them from PIP daily living and thereby the UC health top-up. This is likely indirect disability discrimination unless objectively justified and proportionate. Many such claimants may also lose carer's allowance, compounding the impact. Sensory disabilities. If you suffer from sight loss or hearing loss, those people will score low in individual descriptors but rely on PIP to manage the extra costs. MenCap and the RNIB highlight that thousands would lose entitlement despite real need, with no sound justification in the criteria shift. People with learning disabilities, autism and ADHD. DWP analysis suggests these groups are less likely to be affected by the rule changes. However, the bill still reduces UC health support for new claimants under age-based thresholds and freezes. Some may lose entitlement despite fluctuating conditions. Risk of disparate impact if the assessments fail to account for neurodiversity effectively. Mental health conditions, e.g. depression, anxiety, bipolar, schizophrenia. These conditions often fluctuate, affecting scoring reliability. Tightening PIP eligibility and linking UC health top-up to PIP creates heightened risk of being deemed ineligible during assessment review, even if long-term impact continues. Critics and mental health charities label the bill discriminatory and potentially driving deterioration of mental health, poverty, and even pose a mortality risk. Now let's go back to our list of rights that are under threat when viewed through the Human Rights Act and the European Convention on Human Rights, because we'll be referring to them again. Article 14, Prohibition of Discrimination, in conjunction with Article 1, Protocol 1, the right to property. PIP and universal credit benefits are considered possession rights. Deprivation without justification may breach this article and protocol. Article 3, Inhuman or degrading treatment. Severe impact of cuts may, in extremis, breach if leading to destitution or crisis. Article 8, Private and family life. If cuts impair independent living, dignity or family support roles, e.g. carers, Article 8 may be engaged. So how would the different groups be affected by this breaching of the Human Rights Act 1998? People with mobility or physical disabilities, losing support can mean loss of independence, community participation and caregiver support. Reduced incomes may lead to forced reliance on others or institutional care, impacting Articles 8 and 1, Protocol 1. Visually impaired individuals and carers, loss of entitlement affects their autonomy and may breach property rights and Article 8 provisions. People with learning disabilities, autism, etc. are possibly less affected, but neurodiverse nuance is lacking and there are eligibility disparities with regards to access to dignity and support. Those with fluctuating mental health conditions, unpredictable cuts disrupt stability, access to health care and support, raising possible Article 3 and Article 14 issues, especially given lack of meaningful consultation data or equality impact assessment enactment. Notably, MPs pressed the Starmer regime to publish a human rights memorandum alongside the bill, but no such detailed assessment has appeared. The UN Committee on the Rights of Persons with Disabilities has already expressed concern that this bill deepens systemic violations in the UK. Okay, so let's summarise. The bill's revised PIP criteria and UC health element reductions are highly likely to conflict with both the Equality Act 2010 via indirect and potentially direct discrimination against disabled individuals via inflexible scoring thresholds and age distinctions, the Human Rights Act and the European Convention on Human Rights through potential breaches of Articles 1, Protocol 1, Article 3, 8 and 14, especially due to the disproportionate impact, lack of proportional justification, absence of proper equality or human rights impact assessments, and the failure to meaningfully consult or accommodate disability across groups. Is it any wonder that disabled rights organisations and disabled individuals themselves have uniformly opposed the bill, citing systemic violations of rights and calling for repeal or significant revision, including co-production of policies, which is what the Starmer regime stood on at the 2024 general election, but there is scant evidence of it in the bill. As we've already covered a great deal in this video, I've decided to record a separate video giving a detailed legal analysis of the Equality Impact Assessment for the June 2025 Universal Credit and PIP Bill and key case law precedents under Article 14 of the European Convention on Human Rights and related equality provisions, focusing on discrimination and methodology errors. I do apologise. Don't forget to click the like button, share this video on your social media feeds, and feel free to let me know what you think in the comments below this video. If you'd like to see more content from me, why not subscribe to the channel and click the notification bell so you know when a new video or community post has been added. And I hope to see you all again soon. See you later.